going to talk about a concept called sovereign immunity, one that isn't frequently addressed in the Ninth Circuit or the Supreme Court. But when it is, it can have dramatic and unfortunate impacts for a company like Tetra Tech. And Grasser versus Tetra Tech involved a claim by Tetra Tech that it had entered into a contract to do wildfire remediation. And in that contract, the other contracting party, the Mechoopda Cultural Resource Preservation Enterprise, which was a wholly owned arm of a Native American tribe, agreed to indemnify them for any breaches of the contract. Well, in fact, the claim was made that the tribe had violated wage and hour laws, and in turn owed an indemnity obligation to Tetra Tech to provide lawyers and otherwise defend it. When the lawsuit was initiated, the tribe invoked the concept of sovereign immunity, meaning that as a sovereign entity, that they can't be sued in the United States of America. Tetra Tech objected to that. It went through the district court and went up to the Ninth Circuit. And the Ninth Circuit agreed with the tribe that, in fact, Tetra Tech was out of luck. But Tetra Tech argued, well, wait a second. They agreed to be sued in any court of competent jurisdiction, and we don't have a remedy because by invoking sovereign immunity, that tribe didn't have any form of court or other dispute resolution available where the claims of Tetra Tech could be enforced. And the Ninth Circuit was sympathetic. Here's what the Ninth Circuit said. Tetra Tech's argument has significant equitable force. Because there is no tribal court available, MCRPE cannot be held to account for its supposed contractual breaches. That is unfair. But we are barred from invoking equity here to assist Tetra Tech. The Supreme Court, while recognizing that immunity can harm those who are unaware they are dealing with a tribe, nevertheless deferred to Congress to accommodate the competing interests. So basically, notwithstanding the fact that it's a completely inequitable result, that the tribe entered into a contract in California to indemnify them against wage and hour claims, that there was no way to enforce that right. And the Ninth Circuit decided to twist the knife and really rub it in by pointing out that they should have known better because of who they're dealing with. Tetra Tech cannot claim to have been unaware of the risks of dealing with a sovereign tribe, including the risk that the tribe may exercise sovereign immunity. The Ninth Circuit concluded by saying, in the long run, this may have an adverse effect on the tribe when people realize that if they contract with the tribe, that they have no rights and no ability to go to court. But that didn't help Tetra Tech. A word to the wise, if you intend to enter into any contracts with the Mechoopda Cultural Resource Preservation Enterprise, you might want to make sure that you know who you're dealing with and you know how to deal with sovereign immunity. John Belcher, Law Offices of John Belcher.